Thank you, Desiree. Good morning to everyone. My presentation is called The Adventures of an Expert on Computing, and I want my presentation to be fun. I want to draw your attention. I want you to ask me questions, and of course, I want you for you to know the difficult tasks that involves being a computing expert. It is a very interesting job. It is very well paid, and it also has a great potential for technical and legal and technical people. I think that it is a career which is becoming more and more important. So, well, I'm a professor in the Polytechnical School of the University of Cáceres, and my associate number is 103. In order to be a computing expert, you need to be part of the Computing Experts Association. I would like to also introduce two people that have been reference for me in the field of computing expertise. These people are Andrés Caro, he's my teacher, he's taught me everything I know, and José Aurelio García, who's also a very important reference. And we have the chance to create a degree in the University of Extremadura of computing expertise. And also I would like to introduce to you my assistant today. This is the person that's going to help me in this presentation. He's going to be asking some questions during my presentation and also clarifying some concepts. I would like to thank, of course, Encibe for organizing CyberCamp. This is actually my fourth or fifth CyberCamp. I participated in Madrid 2015. I did a presentation on forensic analysis of disks. I started working on this field in 2015. This picture was taken by Juan Díez, together with Aitana and Guillermo, and other colleagues are in charge of doing an investigation tasks for Encibe. In 2016, I brought some students from the University of Extremadura to participate in the Hackathon of León 2016. I think this is very important. And in Málaga 2018, I gave a presentation which was kind of controversial because it was about authentication systems of university. And what was my presentation about today? Well, my presentation is about 4 cases, well, 3 real cases of on computing expertise, and also some problems and recommendations about these professions. These cases are completely real. These are my so-called adventures. The first case is about an information leak, a leakage of information. The second case is about an investigation in order to invalidate some digital evidence for a trial. The third case is about taking some payments between a company and the administrations. And finally, I'm going to talk about these difficulties and recommendations. But my objective in the end in this presentation is to explain real concepts applied to these real cases, concepts related to computing expertise that may not sound very important, but that in the end are significant. And I want you to be aware that this is important and that we need more computing experts. So, first of all, I want to ask this question. What's forensic analysis? We all know some forensic experts, but we all think about doctors, right? But forensic analysis is a specialized technique that allows us to identify, preserve, and I will explain this later, and analyze digital evidence that are going to be presented in a legal procedure with the maximum technical and preservation guarantees. We will also talk about the custody chain, and in one of the cases I will explain this chain was completely broken. Doing this forensic analysis is a methodological process. We need to be very methodological. We need to know legislation in depth, not to break or violate basic rights of people. And we need to also pay attention in order not to invalidate digital evidence. We will see also how to do that. And also we need to be experts. We need to have expertise knowledge, because afterwards we will have to face a lot of we will have to face judges, lawyers, and we will have to talk to them and answer their questions. So let's start with the interesting things. The first case was a case related to an information leakage. These are real cases that happen on a daily basis. In this case, we had an information leakage, and the investigation needed to find out if an employee of a company with a patent was stealing information. And I'm going to give you more details. What was the context, the background? When we do an expertise report, we need to explain the purpose of the report. This was a company with a patent that was in charge, was devoted to manufacturing doors. So what is a computing expert doing in a door manufacturing company? Well, it's a good question, but I was working there in that case. So then we have the employee that we need to investigate. This was an investigation job. And when the company contacted us, at first they said that the employee was stealing information from the company. After the holidays in August, they saw the employee putting a USB in a computer of the company. And after holidays, when they started manufacturing new designs, the employee was not working there anymore, and they couldn't keep on working on the new design. So they had a problem with the new designs, and this is when they decided to let us know about this problem. One of the biggest problems when you are working as a computing expert in a situation like this one is understanding the context, the scope, and the limitations. This is why my assistant is saying here, you must think before acting. This is an important thing, an important idea to keep in mind. You need to know the system very well before doing anything. In this case, the employee was working in a manufacturing chain, in a production chain. There were like 8-9 processes involved, from the cut of the materials, the design, assembling, testing, etc. The employee was working specifically in the design area. So first the material of the door was cut, and then the design process took place, in which more accurate cuts were done in the door, etc. And the important thing to take into account is that the company had a patent. They had an assembling system that made them very competitive. And the employee, as I was saying, was working in the second process of the production chain. He was working in a machine that was connected to a computer and that was in charge of performing the design. So, okay, this is the context, we are understanding it. So, as we can see, the employee had to type or to work on the computers in order to generate the designs, and the designs were generated with some coordinates. This machine would interpret the coordinates from the computer later and apply them. So Second thing that we need to do is to establish the facts. So we've said that in our report we need to say the purpose, the scope, and now we need to establish the facts. So first thing that we started thinking as experts and investigators was that we needed to study the information that existed in that USB. So before acting, before doing anything, we needed to analyze the information existing in that USB. Then we had to compare that information and to see if it was related with the production information of the company, which is logical. And then we had to look for possible evidences that show that there has been an information leakage from the company. We need to look for the evidence that show that there was a leakage of information. And well, also in all reports, we are going to say that the expert is not going to assess the content on the digital evidences. The expert is just going to use the information in order to establish that possible leakage of information. So that's the starting point, so to speak, and this is how or when we can start working with our digital evidence. Our digital evidence was once so far, which was the USB that the company gave us and that the police had taken from the employee. So the police force was involved. I was saying before that it is very important to preserve the evidence. This means we don't have to alter or manipulate the evidence, because otherwise we are going to invalidate the evidence. So here we are in a position of advantage compared to doctors, forensic doctors, because we can take the digital evidence and we can do an identical copy, and that's exactly the same as the real evidence. As you may imagine, forensic doctors cannot clone, cannot duplicate people. So this is an advantage that we have. This preservation of the evidence is done through different cloning softwares. We can do an image of the pendrive of the USB and clone that image, and we have to also show that the evidence is also preserved, and that the if we calculate the Hans code, which I will explain later, we can guarantee that we have an exact copy of the evidence. In this case, I didn't know if the police forces had done a duplication of the USB before. So we duplicated this USB before a notary, and we left a copy also on that notary office in order to preserve this custody chain. So next thing that we have to do is analyzing the information on that USB. So once we have the copy, the truthful copy of the USB, the real USB is not being used, was not being used. We are working all the time with the copy, with the replicate, because if when working with the USB we make a mistake, we delete something, we change something, we can clone again, we can duplicate again the original USB and restart the process. So this is why working with a duplicate is important. So once we started analyzing the USB, we realized that there were files which had sequential namings from 1 to 520, and these files contained the design, and these files contain the design of the machine used in the design process. So what's next? I want to ask you that question. Once we've analyzed that information, what should we do? So our next step is starting the investigation. We have to go beyond. We need to look for things that may not be visible. And this implies looking for information exhaustively. In a USB, we can look for the hidden information. When we put information in a USB, when we put music, etc., and afterwards we delete that music physically, you are not deleting that information. I mean, something, a physically deleting something is when you delete with an eraser on a paper. But when we are talking about the computing field, there is a logical erasing. You are going to delete something in order to have space to put more things, but the information is still there, and that's what the forensic analysis implies. We are going to recover this deleted information. Once we've deleted that information, we can study the metadata, which is something very important when drafting an expertise report. And then we have to order to organize that information. Do you know what we found out? Well, when we did that information analysis, we realized that we had files from 1 to 520, but there were deleted files from 121 to 867. And there was other type of information too, such as index that indicated to which part corresponded each design, and also there were images with work commands. So first evidence is that there was information deleted from that USB. So now what? What's next? So once we found that, we needed to count on other digital evidence, which is the computer of the company. We went to the company, we got the hard disk, and we did a copy of the hard disk and gave the original hard disk back to the company. What for? Well, in order to establish if in the computer of the company they only had files from 1 to 521, and if the rest of files had been deleted too, as in the USB. When we did that process, we realized that in the computer of the company there were only files from 1 to 519, and they were all visible. But in the USB, we had files from 1 to 816, as we've said before. So you can start guessing what's happening here. What were our conclusions, which is the most important part? Because, of course, we can draft a report, which may be very technical, but in the end, conclusions need to be clear so that a judge or anyone else can understand what's happening. So we showed that the USB was connected to the computer. That's the first thing we could show. We can get to know which devices have been connected to our computer, and we can also check the serial number. And what else could we show? On the 13th of August, we showed that the files had information related to the production activity of the company. Also, we could prove that the USB had deleted files that were related to the designs of the activity of the company. And finally, we need to be clear in our conclusions, and we said that there were deleted files that were just stored in the USB of the employee and not in the computer of the company. So this explains a little bit more the situation, what happened. Then the court statements in courts. This is image or of a court, of the disposition of chairs and tables in a court. Normally, experts intervene at the end. So at first, the different witnesses intervene, and at the end, there is the intervention of the expert. It's what usually happens. When I went to the court, I was there in the door waiting to be called, and they called me the first to declare, which was quite weird. And the judge asked me, could we consider the device as a security copy? No, because in order for a device to be considered as a security copy, it must be stored in two devices, not just in one. Had the files been created during working hours? This is something that I didn't understand at first, but they just asked me that question. Yes, the files had been created during the working hours. This was written on the report. When I started, I didn't know why these metadata were useful, but sometimes you have questions such as these ones, and you can answer because of that information. And also, had files been erased after the employee went on holidays? And I said yes. And can you know what's the date of a file once it has been erased? No, but when you recover it, you can get to know that information. So the judge asked me if files had been erased after the 13th of August, after the employee went on holidays. And yes, it was true, because there were files from 14th, 15th of August, or even from September, that had been erased. So if they were created after the 13th of August and then they had been deleted, it means that some files were erased with a date later than the 13th of August. The employee said that he needed those files because he needed to work at home. He didn't have enough time to finish during the working hours. However, the files had been created during the working hours. And well, and the employee anyway was saying that he was taking work home. So, well, as a summary, and regarding the resolution too, the summary here is that, first of all, we need to understand the context, the background. We need to preserve the USB. This means we need to replicate, to clone the USB. We did this before a notary, and we left a copy there too. Also, we must have we must do an information analysis. Then we need to start doing the investigation, and we need to start recovering the information of the USB, these deleted files. Also, when we saw that they were files that had been deleted, we decided to duplicate the hard drive, the hard disk of the company, of the computer of the company. Then we also recover the information of the computer of the company, compare the results, and deliver an expertise report. Of course, after that, the employee decided to report the company. And the conclusion of the sentence, the conclusions of the sentence were similar to the conclusions that we've drafted in the report. So the judge completely trusted our report and the expertise information that we gave him. Now we are going to move to the second case, which was the invalidation of digital evidence. This was a shocking case for me, and I'm sure it will be a shocking case for you too. This means that in a court, sometimes in this case, in a court, some digital evidence were presented. But I'm going to give you more context. So there was a building company that was in charge of building houses and buildings in general. It's a construction company in general. And well, the bank can provide loans to companies. So the company and the bank were fighting for a loan of more than 20 euros. 20 million euros.
Segunda peripecia.
It's important to say that experts, computing experts, do not have a salary based on commissions, which would have been very interesting for us in this case, with a 20 million euros loan. So, well, the scope and limitations. We saw that there were 3 digital evidence that could be used as contracts. So the problem started here because it was said that this loan granted in 2008 had toxic interest. We've all heard about this toxic interest of some banking entities, but the digital evidence that the banking presented in the court were not presented on the right terms, and we will see what happened later. Have you seen what happened to my assistant? He's turned around because he couldn't believe what he was seeing. Seriously, are these the evidence? So there was just a CD with a phone conversation from 2008 that at first was not gathered as an evidence, but that was never sent to the construction company. So at first, 2 CDs were delivered, one for the jury and one for the construction company. And also the other evidence were 2 emails that were provided as screenshots. That's not being very serious, right? So this is a very serious case with a 20 million euro loan involved. And these are the digital evidence provided by the banking entity. The conversation was 7 minutes long, and we tried to establish if the conversation had been cut at some points and if the conversation had been manipulated. Then we moved to establishing the facts. We studied the audio CDs provided corresponding to that conversation of 2008, and also we analyzed if the emails were valid or not. The expert, again, is not going to assess the content of the digital evidence. We are just going to treat this as technical evidence from the technical point of view.
And I need to make a comment here. The electronic signature law says that an electronic document is the information in an electronic format, in an electronic support, which can be identified and treated in a different way. We are used to printing emails, but that's not the format. You need to hand them in with the integrity and authentication principle. And how can you get that integrity? You need to extract the ID card We all have our own identification number, which is the hash, which is going to guarantee that the copies that we can make from me are exactly the same as me. So you need to have an identical copy of the original. Okay, so far so good. And then authentication. It is important that professionals who are following the professional code are in charge of drafting this expert's report because they have proven their qualification. Some recent sentences are discarding experts' report because they didn't have this required qualification. It is important that the evidence has not been tampered with through documentation of the access process, obtention, transference, and storage. We also need to follow those rules. So we have to follow those principles which are essential. Authenticity and integrity. Okay, do you remember where we were at? We were saying that we have 3 digital evidences, CDs, 2 mails, but the CD never reached the construction company, so we requested the copy from the court, but the court had lost the evidence. Yes, as you hear it, the court had lost that evidence, and that's when you start to be angry. What the bank did was to talk to the construction company, and they said, I have a copy and I can send it to you. So here I just analyzed the generation and modification dates from this file, from CD1. But some days before the hearing, by chance, they found the evidence because we had requested them to look for it, and they found this phone call, this phone conversation, which was the only evidence between that conversation between the bank and the construction company. But this, even if they hadn't seen anything, a conversation can be considered as an agreement. So when we analyzed the CD from the court, what do you think that happened? The conversation was made in 2008. Here we have a copy of the one extracted in 2018 by the other part, by the bank part. Do you know what happened? We got the CD, and when we analyzed it, the lost CD, the creation, the date was January the 1st, 1995. And I'm not kidding you. This is not a joke. I guess you are as shocked as I was. When I saw it, I thought, okay, this is wrong. It's something that cannot be possible. But it was true. I mean, this was a falsified evidence. It had been tampered with. We cannot see the name, the kind of, the format, the date. Didn't match. There were 2 completely different evidences. And then we have email 1 and email 2, which were in PDF format. When you print an email, it doesn't guarantee its legal validity because you can scan them and tamper them with. And we can make Batman to speak with Spider-Man if we want in an email. The mail is a file. In our Gmail account, we can push a button to show the original in order to download it, and there are different files in different formats. But it is necessary to identify the header of the Gmail with the person who sends the email, the person who receives it, and so on. As a conclusion, we extracted several conclusions. The main one is that this expert affirms that from the expert point of view, the digital evidences are invalid. CD1, CD2, email 1, and email 2. Why? Because these evidences were not presented according to adequate computing experts' procedures, and the custody chain was lost, and then we couldn't know where the original had been created. So imagine myself going to a trial, invalidating the digital evidences. Can you imagine what happened in the court? In the beginning, the judge didn't want to accept the expert's report, first of all, because she wanted to assess the whole case as if evidence were true. Reasons for that? Opaque, obviously, because those evidence hadn't been presented in the appropriate way. And then questions by the judge. But I would have loved to ask the judge, who extracted that conversation in the bank? Was it tampered with? Because I saw there were some cuts in that conversation. Is the expert's report invalid? I mean, I think judges need to trust technical teams and at least accept and assess what's going on, even if it's not nice. I told you that I was going to share my opinion, and I'm doing it. In this case, the bank won the trial, and they didn't want to recur to other higher courts. So how digital evidence should be presented? Well, like this, CD1 and CD2, with the name of the file, the size of the file, the extension, the day of modification, the time, and hashes. MD5 and any other hash, because you can use different hashes, which are encryption algorithms. You have the file, you use this algorithm, and then you have an alphanumeric code that identifies uniquely that file. You can tell me encryption algorithms are broken. Yes, they are all broken. That means there have been collisions, which means that two different files had the same hash. But it has never been proven that two hashes or two different hashes for the same file. That has never been proven. In the documentation index, which is available for different lawyers and the judge, they have the hash that identifies every file, whether it is electronic or not. Case 3. I know that the two first cases were high level, and this one is softer, okay? And this is the checking of settlements. An expert can start an investigation process looking for evidences. Secondly, we can check the validity of those evidence, and in this third case, we are going to compare some data with other data, especially with economic issues in between. I am going to speak about a bus company. Yes, I am a computing expert, but I am working at this bus company. And then, on the other hand, we have a public administration. So you might think, what is the relationship between them? Well, this bus company is offering a public service because transport in regions are funded by general funds, and this is what links them. So the services that this company provides, and then the funds that the public administration gives them. And then the problem comes when these numbers do not match. So we need to compare the services from the company with the funds by the public administration. If a bus provides the service every Monday, Wednesday, and Friday, obviously all those days have proven to offer a service. And then if the days do not match between both parts, then you need to hire an expert, a computing expert. Every service, which means every time a bus starts a route, there was a line created in a TXT, in a text file, and every ticket bought also generated another line in a text file. Eventually, those lines in the TXT files were the output that the company sends to the public administration in order to carry out the payoffs every 6 months. So the company sends these documents and the public administration pays every 6 months. A little comment, TXT files of 2 megas or 3 megas. So you can imagine how much information there was according to services and tickets. And the payoff was made in an Excel, and we needed to compare both Excels to see the difference. So I had to wait. I still have to wait to go to the court, but the first thing is that it is impossible for the public administration to have had reliable control on the services provided by the company, because the company is the one that sends that information. And every month, this report is sent to the public administration. That system is not well designed for a public transport service. The bus should send directly to the company and to the public administration that information which is generated, and it shouldn't go first by the company. That information should be sent at the same time to the company and to the public administration, which requires a change in design. Logically, both files do not match. The public administration, the information doesn't match with the bus company's information, and there are quite a few differences between them. And something like that is quite weird. But as I said, we still have to wait. But I wanted to explain to you this procedure of analyzing and comparing different files. It's been 8 months of hard work, and in the end, we have reaped some fruits, and we have extracted some conclusions, and we'll see how it ends. I'm going to move on to the last part, which is difficulties and recommendations. What are difficulties that an expert faces? Well, you may already know them. I worked for a company that manufactures door, bus company, an agricultural company, a real estate company. So those are the cases that I have been in charge of in the last years, and the difficult part is to get to know in depth the context and how you can isolate all the evidence so that everyone can understand it. That's the most difficult part of the expert, because as for the technical part, once you start working with evidence, is no longer interesting. What is difficult is the new challenge of facing different procedures and processes within companies. You don't know those processes. You need to learn. I have learned a lot about buses. I didn't learn that much about doors, but about buses I did. And you need to isolate all the case and to build the case. That's the most difficult part. As for recommendations, an expert needs to be unbiased, objective, and needs to know the responsibility, because it is not only about telling the truth. When the expert gets to know the faults, there is no other option than telling the truth, being responsible and objective, and act as an expert should act. And this is the last thing, which is the professional code, the ethical code. All computing professionals and in the field of communications, also doctors, every professional group has an ethical code which is designed to comply with several aspects which cannot question our value. We need to be objective, we need to keep confidentiality, integrity, and to have skills. I mean, you need to have enough skills and knowledge in order to face different cases with warranties. And if you are not an expert in some fields, do not worry. You can discard that case, you can reject it. I'm getting to the end of my presentation, but I wanted to mention that recently I have found that digital evidences are not presented in the appropriate way. Judges have the power to admit an evidence which may have been created in an invalid way. And there are some parts, especially social and labor part, which allow those evidences. However, in criminal courts, they are more strict, and I think all the courts should be as strict, that strict. Evidences are not well presented, however, they are not rejected, and that has a consequence on the dispute. And in the end, that part is going to be the one that pays for it. So in the last cases, I'm working mainly on WhatsApp conversations. Logically, our life is on social media, and many of our conversations take place in WhatsApp. Since WhatsApp created the option of deleting your messages, was a very important moment for experts. You need to check if the mobile phone is not rooted. You need to know if there is not a security copy with a date later than the conversation. It is not easy to tamper with WhatsApp conversations, but it's possible to do it. And it is also possible to have another device which is rooted, another device which is not. You tamper with conversations in that rooted device, and you deploy the security copy in a non-rooted device. That's why we need to do those verifications. Today, in trials, we still allow to present screenshots from WhatsApp, because the one which contests is the one who is going to pay for the expert's report. But what happens with WhatsApp? In a case in which we have a conversation on a screenshot, and then I go to my client and say, contest the evidence and delete the messages in your devices. At the moment when you're contesting the evidence, you're saying that it doesn't guarantee the custody chain, and then the other person deletes the messages, which will never be recovered, and lawyers then lost the digital evidence. This is the end of my presentation, and I wanted to make judges and lawyers understand, and maybe experts need to be more prepared. Maybe we need more experts, but I think that judges need to understand the responsibility they have in order to only accept evidences that are presented in a correct way. I hope that today's intervention was interesting for you, and I would like to thank you for being here, and I will continue with my adventures to talk about them the following year. Thank you very much, and open to any questions you may have.
Que se ha trucado, ha variado unas grabaciones o unas pruebas digitales. Pero claro, en ese caso has puesto que las grabaciones...
You said that recordings were online, so it was a copy from a computer, but in an audio recording, and you want to change the date, that recording is played in a loudspeaker, and you record it in your laptop, and you record it with whatever quality it has. How can you know it is the original one or not? You cannot know it. In these cases, this digital evidence may be in a system that the expert is going to use in order to extract the audio file in an appropriate way. For example, if we're speaking about a WhatsApp conversation and there is a two-part audio, there is an audio, maybe you can ask the other person who received the audio file to check if they are the same. But it is true they can be tampered with. The expert in that case needs to check if the second evidence, the one that is recorded on the loudspeaker, needs to check if that's the original one, because if we're speaking about an audio file or about a WhatsApp conversation, I don't want them to show me the conversation extracted in a different computer. No, I want to intervene in the system that records. Otherwise, I won't present that evidence in court. Either I extract it from the system that recorded the audio because I know it's the original one, or I won't present any evidence. So, for example, we have recorded you right now. So if I play the sound and I record it with my computer, you cannot know if you have spoken today or any other way. And when you record that in a CD, are the metadata still in the computer? Yes, for example, when you record in MP3, the metadata from the original file are still saved. You can do it in PDF, Word, an audio file, whatever. If it's online, the data are stored, right? But if you change your computer's date, can you know if the date has been modified? Well, if you have done an identical copy, so Ctrl+C, Ctrl+V, of any electronic file, that's an identical copy to the original one, okay? No, in that case, I wasn't referring to an identical copy, but to record from the original Y. And then you disconnect from the internet in order not to update the date, and then you emulate the moment. Yes, that's the conclusion I extracted from the conversation of the conversation. It was a manipulation. It was a tampering. So they tried to modify the date, and as you saw, it was 1995. But if you do not have an evidence to match it with, can it be admitted? Yes. I'm sorry, guys, but you're running out of time. You can keep on discussing outside. Please, a big round.